I have a real privilege of introducing Randy Johnson for several reasons. So first, he is the only speaker today who has received, count them, 19 different inbound requests to ask if we will be live streaming his presentation. The answer is no. We're not live streaming your presentation. However, I have responded to each of the 19 requests, which are not following any particular demographic, but obviously fans of yours in some way, that we will be posting your presentation in several days because we will be taping it. So when you do ask questions, I'm going to remind you, if you wouldn't mind, in this case, coming up to the mic and asking the question to the mic. And if you're seated and you raise your hand, I'll probably grab the mic and run it to you so that we can just get the question onto the same video so it makes sense that Randy's not answering a question that no one else hears. Okay, so with that in mind, let me introduce Randel Johnson. He is the Senior Vice President of the U.S. Chamber of Commerce, and he has a broad set of responsibilities which are near and dear to all of our hearts. They include labor, immigration, and employee benefits issues, largely issues that come before Congress that are pending in front of federal agencies. He is not just a guru on these issues, but actually a very well thought of spokesperson who can be counted on to bring analysis that typically is lacking. And so everyone from Ben Johnson, who's the Executive Director of the American Immigration Council, to a number of people in AILA rely and trust him to help bring color and flavor to the immigration debate. And so he was willing to come out all the way to the West Coast to spend time with us and to give his, I hope, fairly far-reaching commentary and then answer some questions from us. But before I let him stand up and talk, I will point out that he is as well or better credentialed and trained than most of the academics in the building. So he has an undergraduate degree, he has a law degree, he spent time at the Kennedy School, he's received several interesting certifications, and he has a master's of law. So don't let him fool you with this kind of easygoing attitude. He could be walking around our halls just as easily as spending time in DC. So with that, let me hand it over to Randy Johnson and thank him.
Well, thanks, Dan. I confess that when I was walking through the quad this morning, of course, getting lost, I was looking at all these budding young law students wondering whether they're going to find a job in this economy, but I figured they can always do I-9 audits after sitting through here. God love them for doing that, not me. But, you know, one thing, I attend these kinds of conferences, not a lot, but occasionally, and with all due respect to the government people, characteristically, you hear from the government people, and I wonder who the streamers were. It might have been the unions or someone else. But it tends to be like, well, everything's sort of smooth and happy, and we all want to get along. And I got to tell you, I mean, what I hear from my membership, and I assume many of you are familiar with the U.S. Chamber of Commerce, maybe you're not, but the U.S. Chamber of Commerce represents employers across the country. We have 3 million members. My labor relations committee is about 500 companies and law firms, and the feedback I get from them with regard to enforcement under this administration is it's not pretty at all. Now, are these just sort of squeaky wheels and they're not representative of what's going on? Well, all I can tell you, these are top-flight law firms, top-flight companies that are saying, you know, something is wrong with this administration and where the enforcement is going. Now, you know, it just came across a couple things here to make this point, just because it all came across my emails just in the last couple of days, 2 of them this morning. We just had sort of a couple of panels on E-Verify, where the National Labor Relations Board recently issued and I'm going to drill down all these issues, but the National Labor Relations Board recently issued a complaint against a company for, lo and behold, what did they do? They voluntarily entered into the E-Verify program. So the National Labor Relations Board, on behalf of the union, issued an unfair labor practice against this company, allegedly for the failure of this company to bargain over its decision to enter E-Verify. The firm representing the unions issued a press release, which I have here, noting that this is a precedent-setting decision by the National Labor Relations Board requiring bargaining over this issue. Now, I just bring that up as sort of an example of kind of the cross-currents you have to face when you're considering some of these issues. And today we've seen just a very narrow slice of a very complicated law, the immigration laws. But of course, that's just a small part of the entire puzzle. But, you know, that's just, and I'll come back to immigration, of course. But had a recent hearing on Capitol Hill on the Office of Federal Contract Compliance Programs. As I told Dan, I'm not just going to talk about immigration. I think I'm going to talk about enforcement generally over the employment area. The Office of Federal Contract Compliance Programs requires, of course, affirmative action on minorities, women, veterans, the disabled, on behalf of government contractors. Hearing just last week before my old committee, the House Education and Labor Committee, one of the witnesses said, kind of going through OFCCP's various policy decisions, but also enforcement, quote, "These include the agency's alleged lack of transparency and guidance with respect to standards it uses to evaluate contractor data for potential discrimination, the lack of consistency in conducting compliance evaluations throughout its 6 regions, and the purportedly negative tenor compliance reviews in which compliance officers, quote, approach audits with an eye towards violations." Recently, the National Labor Relations Board issued a regulation requiring all employers to post a notice of so-called employee rights in the workplace. Now, you might say, what's the big deal about that? And what's wrong with that? The real issue is did the board have that authority? And for 75 years, since the National Labor Relations Act was passed in 1935, it didn't. And we challenged that decision in the Court of Appeals or the District Court down in South Carolina. And the court just came out with a decision a few days ago saying, yet there is not a single trace of statutory text that indicates Congress intended for the board to proactively regulate employers in this manner. And I'll come back to that. Now, just this morning, I've been trying to help a company out, a small company up in New York. It's getting its ass kicked by the Department of Labor over alleged violations for prevailing wages. The back pay liability in that case was peanuts. It was $3,000 to $6,000. DOL is pushing for debarment of this company, which of course would have meant, frankly, the end of that company. So they've been working to reach an agreeable settlement. And just today, I saw some of the paperwork on this. The attorney noted, parenthetically, in my many years as a prosecutor, inspector general, and private attorney, I've never seen such overreaching by an arm of government. Now, that's one lawyer, one case. But in just this 4 cases, I've covered the National Labor Relations Board, Immigration, Department of Labor, Wage and Hour Division, and OFCCP. Again, the feedback I get from my members is we do have something wrong with this administration and the way it's approaching employer compliance. Now let me go back to immigration here a little bit. And I know we have the esteemed judge here today, and she may have some comment on some of these cases. But we've heard from several people from the government here, from INS, or they don't call it, from DHS, sort of talking about the reasonableness of fines, et cetera. And I just had one of my immigration people pull some cases for me. And a series of cases have been brought against small companies recently, small to medium-sized companies. I want to reference those. And it's not so much what happened at the end, it's what happened at the beginning. Sort of a famous one, Ice Castles Learning Center, had about 60 employees. ICE fined the business $179,000. The amount was appealed down to $39,000 and further finally to $18,000. Another case called U.S. Snack Attack, which came up earlier. Total fine initially was $111,000. The total fine was $27,000. I could go on with about 6 more examples where the initial fine is an amount that would have put these companies close to out of business, and it was bargained down to a reasonable amount. And actually, these cases were before the judge at some point. So I guess what's going on here, I'm not quite sure. But when you're thinking about employer compliance, and for those of you with companies have to look beyond just sort of this initial stuff we're talking about today in immigration, I think we are seeing a very anti-employer attitude in this administration, and it's one that I think it's up to all of us, certainly those who represent employers, to try and pull together in a story and document so that we can go to get relief from Capitol Hill or wherever, and we certainly intend to do that at the chamber. Now, so let me drill down a little bit in some of these cases. Now, it's one of the frustrations about my job is, and I do 50% of my work is probably on Capitol Hill, 30% regulations, but the rest is kind of that subterranean area which no one finds really sexy or interesting. I mean, legislation, we have our big battles over the Employer Free Choice Act, healthcare, all which was in my portfolio. Hit the headlines, and those are fun and interesting. But it's really kind of simple because you kind of know where the parties are. Substantive arguments, certainly on the Employer Free Choice Act, were clear. Healthcare, a little more complicated. But that's where the focus is. And then below that is regulations, of course, which we've talked about today. And then below that, though, really is the stuff that doesn't get the attention of policymakers because it's complicated, it's very fact-intensive, which is sort of regulatory guidance. And then below that is really what happens in the enforcement level. And yet, conferences tend to sort of, as I think we've done this today, is we sort of look at those as separate little things, but they're all interrelated. And I think, Charles, you mentioned that the first thing a lawyer should do is look at, I think you mentioned, look at the legislation. But in reality, most companies, unless they're well lawyered and have a ton of money, the compliance officer is going to come in and they're going to decide what they're going to do. And you have the wherewithal and, of course, the theoretical right to be able to push that up through the system and go back to the statute and contest the compliance officer's decisions. But that costs a lot of money, and in fact, that's relatively rarely done. And certainly anybody, and I spent 6 years with the Department of Labor prior to this job, well, prior to my time on Capitol Hill, and it's a tremendous amount of power that's exercised by these agencies. So, and you could push sort of that issue where you want to go on enforcement, and if you don't want to, if you're not sort of happy with the enforcement, you can, of course, change the laws or change the regulations. So I'm going to kind of run through some of the agencies beyond INS here, so you kind of have a feel of what's going on here. I mentioned the National Labor Relations Board posting regulation got struck down in the circuit in the South Carolina District Court, the U.S. Chamber of Commerce versus NLRB. The D.C. Circuit upheld that, but it found that while it found that the board had the authority to require a notice, it found that, and this is very important, of course, to the administration, it found that they did not have the authority to create new unfair labor practices under this regulation, much less toll the statute of limitations and other regulations under the National Labor Relations Act, because that was not within the statutory authority of the National Labor Relations Act. Following right behind that is something called the ambush election reg or speedy election regulation, which essentially shortens the time period from which the board can schedule an election from when the time the union files a petition for an election to the time the election must be held. Traditionally, it's been about 35 days. That amount of time has usually allowed employers to educate employees with regard to the pros and cons of unionization, and then they go to the polls and vote. Under this new regulation, that's going to be shortened probably to about 14 days, largely to a lot of seemingly technical reasons, which NLRA lawyers would look at that and say, well, it doesn't make a lot of sense, but if you piece it together, this is what's really going to happen. Now, why is that going on? It's because, again, they're changing the rules of the road with regard to how unions are elected. And if you look way back to the Taft-Hartley Act and the labor law and Carter's Labor Law Reform Act, most recently the Dunlop Commission, you will see that this is sort of shortening the election time has always been on the sort of the favorite list of the unions in terms of a change they want under labor law reform. This is an effort to get through that through changes in the regulations rather than upfront through the statutory procedures. Now you say, well, what's important about that? Well, I can tell you certainly for those employers who are facing union campaigns or not, it's extremely important. It's probably one of the top priorities of the employer community to defeat this regulation. Again, this is an example of because the regulatory procedures in and of themselves sort of don't allow the administration to get where they want to get. They're going to change those, and of course that filters down to the enforcement side. We have challenged this regulation in the D.C. Circuit, and we'll see what happens. Injunction request is pending. Combined with that, again, is a regulation coming out of the Department of Labor called the Persuader Regulation, which changes the rules with regard to when you as an employer can hire a labor consultant, must that labor consultant report its clients, not just you as an employer, not you as a client, but all its other clients, to the Department of Labor on forms under the Labor Management Reporting and Disclosure Act. Phrased another way, under the LMRDA, there's long been an exception called the advice exception from the Persuader Regulation. If you're a persuader, you have to report. If you only provide advice to the employer but not to that employer's employees, you don't have to report. Under this new regulation, you will have to provide disclosure to the Department of Labor on public forums, which is your relationship with all your clients, if you're providing advice just to that employer and not to the employees. Again, why is that a big deal? That came out the day after the so-called speedy election regulation combine those two are going to make it very difficult for employers to get the kind of counsel they need in union elections. Obviously, case law, which I notice in the immigration area, there's not a lot of case law that kind of drives decision making. Most of it is by guidance. A few cases go up. In the other parts of employment law, of course, it's extremely common. The National Labor Relations Board is on a very aggressive agenda to change the whole standards through case law, such as what constitutes a proper bargaining unit when it comes to unionization. A big case came out called Specialty Healthcare, which essentially said, if you as a union propose a unit, then the employer must accept that decision unless the employer can show that there's an overwhelming community of interest that shows that the unit proposed by the union is improper. The essence of that is basically that in virtually every case, the unit proposed by the union will mean that that is the unit accepted by the board. Typically, that's going to be a very small unit because that's easier to organize. Again, this is one that's been long on the list of the union agenda, and here we have it sort of being pushed through changes in case law. Now, the NLRB is an independent agency, as this administration is quick to point out, but two of its three recent appointees have all come out of the union movement. I can tell you that no one from the U.S. Chamber of Commerce or any other sort of similar employer group has ever been appointed to the board. So it's true it's an independent agency, but the policies are being driven from the top to reach a certain end by the administration. Office of Federal Contract Compliance Programs, for those of you who are federal contractors, I mean, in my 15 years of doing this, I've never seen so many complaints coming out of companies with regard to an agency. It's going to change its regulations with regard to compensation analysis, with regard to affirmative action for the disabled, to veterans, all of which we support at the Chamber, but these regulations have really swept too far. More importantly, what we're seeing is at the ground level, and this is enforcement, again, it's not really what the regulations are. You can have the best regulation in the world, but if that person at the ground is enforcing that regulation in a certain way or with a certain attitude, unless you're going to go to court or bump it up, you're out of luck. Now, in the OFCCP area, what happens if you do that? Well, you risk debarment. So even the largest kinds of corporations really, they take what's given to them with a pound of salt and a teaspoon of vinegar, I should say, and don't contest the agency's power because they're afraid of losing and being debarred. So that is a tremendous amount of power, which empowers the enforcement people. There was a hearing just on the Hill on Wednesday. I just kind of want to give you some of the examples of sort of what we're seeing at the compliance level under OFCCP. OFCCP staff, and this is feedback from my members of the Chamber. OFCCP staff telling the contractor that it was welcome to bring a matter before an administrative law judge, but, quote, the judge works for us. So in other words, go ahead, but the stack is already decked. The ALJ's on our side. Agency staff using strong-arm tactics and employee interviews to get the answers they want to hear. Employers passing an audit, and then investigators returning and reopening the investigation until they can find a violation. OFCCP is not interested in discussing narrowing the scope of its information requests, rather than data in problem areas. OFCCP wants data on everyone. I could go on this one. I think the point is what we're seeing is not just in OFCCP, but also in EEOC, which I'll get to, sort of a real push on government power in saying, look, we want all your documents, we want all your data on compensation, and if you don't like it, you can sue us. Again, in my close to 20 years in this area, I've never seen it sort of reach this level. You talk a little bit about EEOC. Again, an agency which traditionally has been below the radar screen. I know most of the commissioners over at EEOC. There's been a series of cases that have come down, really remarkable from the court, slapping the agency back in cases where one in here, in a gender discrimination case, the court sanctioned the EEOC for $2.6 million in fees and costs after the agency refused to identify the woman it was representing. The court stated, quote, the EEOC is engaged in a, quote, reckless sue first, ask questions later strategy. In another one, in a race discrimination case, the EEOC alleged that the staffing company's blanket policy of not hiring individuals with a criminal record had a disparate impact on African Americans. However, the plaintiff in this case, People Market, this is all public record, simply did not have a blanket no-hire policy. Despite becoming aware of this issue, the EEOC proceeded with the litigation anyways. As a result, the court sanctioned the EEOC a total of $751,000 for proceeding with the case. Another one, courts dismissed a pregnancy discrimination lawsuit filed by the EEOC, which based its claim on the theory that the company did not provide a sufficient quote-unquote work-life balance for mothers working there. The court ruled that the law does not mandate work-life balance and that employers are not required by law to treat pregnant women and mothers better or more leniently than others. The court criticized the EEOC for using a sue first, prove later approach. We've also seen in the EEOC situations where under the law, if you read Title VII, which was mentioned in one of these panels, under the law, EEOC is in fact required to conciliate before it brings a lawsuit. What we've seen recently from the agency is their conciliation is basically, here's our offer, take it or leave it. And the agency has been slapped back by the courts in some cases in that situation. Again, this is why wouldn't, if you're looking to enforce the law in a reasonable manner, particularly when the statute mandates that you do that, why wouldn't you approach the employer, put a reasonable settlement offer on the table, and try to work with the employer? Now, this is a mix of a lot of things, and I realize that. But I want to talk a little bit about cost because very few people ever focus on the cost of regulations because as they work their way through the system, and this is more process, but as it works its way through the system, certain regulations, if they're under 100 million, they come under less scrutiny by virtue of the executive order in Congress than if they're over 100 million. So in that case, there's a built-in reason for the agencies to try and lowball figures, besides the sort of obvious PR problems of high figures. Now, we did our own calculations. Out of 6 Department of Regulations, the Department of Labor calculated a total compliance cost of $250 million. Our estimates, now maybe we're a little on the high side, was $4 billion. One of the OFCCP regulations I was mentioning, this is dealing with veterans and affirmative action. And let me caveat that I was on the Hill when I worked on the Americans with Disabilities Act, and certainly was one of the prime staff authors of the ADA, and the chamber is on the forefront of employment of veterans. But in these cases, these regulations have sort of taken good ideas and gone too far. Now, in one case, OFCCP totally mandates required training programs for all employees covered by federal contractors for these new regulations. Well, what did it conclude the cost of that? Well, it concluded there was zero cost. Obviously, there's close to 22 million employees covered by federal contractors. Each one of these must attend one of these classes. We put the estimate of about 700 million. And you know, we go through these regulations in each one of these, and these are part of our challenges to the regulations as we go to court. But I guess, and I could go on with some of these other lowball figures. I think the point is we've got a lot going on here on the enforcement side. We've got changes on the regulatory side, and then we have a disingenuous effort to cost out those regulations for the public to really evaluate what, in fact, is the real cost. And that's, of course, one of the problems on our side where we've got to hire an economist to go through each of these and figure out what, in fact, is a realistic cost. Now, okay, so there's regulations, and then there's, of course, all that area of guidance, and that you don't need notice and comment rulemaking. So what happened with a couple of things going on to give you examples of this? OSHA came out with a guidance document about a year ago, which changed the criteria by which you evaluate whether or not you have to use hearing protectors or engineering controls to determine whether or not you've met the level of protection for hearing. It's actually a complicated issue that affects many in industry with engineering controls versus personal protective equipment. OSHA came out with a guidance document saying, well, this isn't a regulation, it doesn't have any substantive effect, and we're not even going to cost it out. Now, we're going to let the comment we're going to let the public comment on it, but we're not going to consider it a regulation, and we'll just go forward with it regardless of the comments. But we costed it out at about $1 billion. As again, OSHA didn't even bother to put up any costs on it, much less benefits, and OSHA wound up pulling that back. EEOC has a similar process going on right now where they're changing their rules with regard to disparate impact and the use of disparate impact for credit histories and for criminal background checks. They were on the cusp of doing that as of last week. We sent a letter to OMB saying, no, this should go through notice and comment rulemaking. And as of right now, we think EEOC has pulled that back from the agenda, is not going to go forward with it. So that's a victory in our sense. But all we were asking was that they go through notice and comment rulemaking. So we see sort of an agenda going on here where it's sure you've got the regs going on, but then you've got a lot of effort to push very important things through that change important policies without going through notice and comment rulemaking, much less leaving those to court challenges under the APA. OSHA, I mean, this is all, OSHA's, the series of initiatives have come up which ramp up the multiplication of civil penalties for certain kinds of violations, for increasing the look back, say from 3 years to 5 years, so you can look back, capture violations, and therefore increase your ability as an enforcer to find someone as a repeat violator. There's a policy a new policy that collects sort of violations from different parts of a company across the country, collect them as one, and therefore you have a basis to find that company as a repeat violator. The D.C. Circuit just last week actually slapped down OSHA for, and we were talking about some of this a little earlier, slapped back down OSHA. OSHA was looking back 5 years and collecting violations for record-keeping violations, and the court said no, under the statute you can only look back 6 months, and that's the end of it. But how much money do you think it took that employer to contest that all the way up to the D.C. Circuit? So I think in sum, there's a lot going on. Now, again, maybe we're just hearing from the squeaky wheels of the chamber, and everything is smooth, and there's not that many problems out there in the real world. That's not what I'm picking up. I think that it's our duty at the chamber, and what we're going to be doing is putting together a major white paper on this issue to try and collect these various stories, fact-check the cases, because it's a very difficult area to separate the chaff from the wheat and figure out, okay, really has the employer been abused in this case or not, or are they just sort of complaining? Look at the regulatory process, what things should be going through regulations that aren't, what are the true costs of those regulations, and try and paint a story of enforcement by this administration. So look forward to that in about 2 months, and it should be a pretty big deal when we get it done. Any questions? Yes, sir.
Let them know. I know the Chamber's public position on. Go ahead.
Randel, the Chamber's public position on federal preemption, I'd love to hear your comments on that, and also
under ERISA, NLRA, or INA?
On the INA, and then also the mandatory E-Verify bill. What do you see its prospects? And we hear that it's an agriculture issue now.
Yeah, I should have backed up that. I jumped right into things, but I've long been involved in immigration issues, including comprehensive immigration reform, long going back to Hagel-Daschle and McCain-Kennedy, and have my bruises from all that. And the Chamber's been very supportive of loosening up. I don't say loosening up. Increasing immigration to this country, including a pathway to legalization for the undocumented. As Morton mentioned, all of these have included provisions in there, typically Title III, to strengthen employment verification procedures, which the Chamber has written much of and supported. After we challenged the Arizona E-Verify case in Candelaria, lost 5-4, and disappointing decision. But after that came down, we thought we had to negotiate with Lamar Smith, who chairs the Judiciary Committee, on a mandatory E-Verify bill, because we thought, and I'm not divulging any secrets here, if that went to the floor, it would pass. And so we thought we needed to cut the best deal. We did. Now, in my view, that has a strong preemption clause in it, In other words, if that bill passed, it would preempt state E-Verify laws. And my membership, I've gotten much less negative feedback on this than I anticipated, and I carefully covered my CYA on this one by having a task force that when we negotiated, we went back to them, including with federal contractors, because they have mandatory E-Verify, that this was a good bill, this would preempt laws, and they would rather get this hot potato out of the states into the federal government. So we do support Smith's mandatory E-Verify bill. It's hung up right now on, and we would support it if it went to the floor. We've met with leadership on this. It is hung up on the so-called ag fix, and it's a well-known secret that if the E-Verify bill went through right now and applied to ag, they would lose a significant amount of their workers. And so Mr. Smith and others have acknowledged there has to be some kind of a fix for agriculture. Maybe it's a super long phase-in. Maybe it's some sort of narrow legalization program for the undocumented who work in agriculture, some kind of return and come back. People call that the Presario program, though, so that's probably not going to sell. So yeah, I think that's the other part of it, though, is you bring it up. There are obviously some people on the left who don't support it because it would have the effect of if it's not combined with something else, would have an adverse effect on some number of the undocumented. There's people on the far right who don't support it because it would preempt state laws. So there's some interesting politics going on besides just the agricultural fix. I do think if we come up with an ag fix, though, it will go to the floor, and if it does, we'll support it, and we'll work on additional parts of comprehensive immigration reform that goes to the Senate, maybe a DREAM Act petition or something.
I appreciate your comments about the NLRB and OSHA and their new rulemaking. This has been going on in immigration, though, for a decade. I call it rulemaking by FAQ.
Right.
I mean, and right now it's having a substantial negative impact on American business and the ability of American business to get the right workers in. What's the chamber doing to try to get Ali Mayorkas and his people to actually follow the law on this? And are you guys willing to sue these bastards to stop them from trying to destroy American businesses as it operates today?
Well, I like it. We work with Mr. Mayorkas on a lot of things, including we're trying to get some changes to the so-called L1B processing criteria. But I will say, I'll throw it back to you guys. One of my frustrations with the immigration bar and employers in this area is they seem very hesitant to ever sue. And I've said this to my immigration people. I mean, where the heck's the fun here? OSHA we sue, NLRA we sue. We're in three court cases right now under the National Labor Relations Board. OFCCP is a little tougher one because of the debarment problems. But in immigration, I will say there seems to be a tendency to roll over and take it. In answer to your question, well, we are in one court case dealing with the H-2B regulation. In fact, there's a hearing on Tuesday down in Pensacola on it.
We're going to win that case, aren't we? Say yes.
Yeah, okay. Hope so. We're also working on an appropriations rider to block the regulation, which we got through in the last Senate in the last bill, but we're trying to get that extended. But I would say in the immigration bar, people seem to roll over and take it. And I agree with you. I've been sharing your frustration with that. What do we challenge it? Yeah, I mean, our members got to come to us and say, this is important enough, which is what happened in H-2Bs. And look, let's face it, it's you're talking $200,000 to $300,000 when you go to court on these things. The L1B thing is interesting, where I keep saying, you know, okay, if the career people are distorting the legal criteria by which they're applying to these petitions, such as, you know, applying a prevailing wage fix or pre-recruitment, which is not part of the law, then maybe we need to go to court and sue. I haven't gotten traction on that yet from employers.
One of the issues that we had when I was able president was we had the willingness to go, but we couldn't get plaintiffs. We couldn't get companies put their name on the line because they were afraid of retaliation from the immigration service. And so part of the theory was, why wouldn't the association sue? Which they seem to have standing. You've done it as an association.
Right.
You have standing. I would assume we would have standing as well.
I would think you would have standing. There does, if you're going to apply for an injunction, you need to sign a declaration of imminent harm, and typically some people have to disclose some employers have to come forward. I'm just doing a declaration now for our case on the ambush election reg. Well, no, it's this other case where we're challenging the president's authority to make the NLRB recess appointments. But I will tell you, I'm not going to name names, but I'm signing the declaration, but we have found it hard to find companies that are willing to put their name on the declaration. And that's an area where people are typically a lot tougher and a lot braver than they are in immigration, I would say, in terms of letting their names be known.
It was collected a whole bunch of examples of the service centers doing this rulemaking. But if you were just changing the rules about it, but it's that plaintiff that we continuously lack.
Yeah, and I guess, I don't know, you tell me, does it have to get so bad that a company's willing to come forward and say we got nothing to lose, or is it, what I often get is, well, let some other company do it, and I'll benefit, you know?
That's really the other guy.
Yeah, that's called, well, we all got to pull the wagon, guys. And some people don't want to help pull the wagon. On the L1Bs? Yeah, no, we had a big meeting. The Small Business Administration's been, you're right, been working to collect stories on L1B denials. And we had a huge meeting at the chamber with Ali Mayorkas. He actually came down, it's publicly known. We had probably 50 companies there, and we had 15 top flight companies talk about their problems. We also sent a letter to the president signed by about 58 companies. Somebody leaked it to the press. I guess I wasn't, but it was like the day after. And all of a sudden, the restrictionists were all over it. And there's been blowback on that letter. And so what happened, happened. So the companies went public on that. That's different, though, than what you're sort of suggesting is, I think, willing to fund a lawsuit and actually take on the powers that be. At some point, that's what the courts are there for. And if you don't, I'll tell you this, and I'm not coming back. Look, these NLRB lawsuits, I'm not saying the posting reg, I was like, hey, great win. But going into it, you got to sue, and if you lose, you lose, but you keep the agencies on their toes, and you make sure the next thing they do it right, or they spend more time getting it right, and that takes them away from other stuff. So this is all a guerrilla warfare, and I'm not even talking about the oversight hearings we orchestrate on the Hill. But so whether you win or lose, it's a shot across the bow to try and keep some normality in the process.
So I just had I guess it's my own personal frustration, but a frustration of probably of everybody in this room. And I know you know because you put out a report stating that there's a tremendous amount of foreign-born persons that come to our country. They invest in our country. They're employed in our countries. They start businesses in our country. They generate billions of dollars. Dan Siciliano can do the statistics on this. It's helping our economy, but I'm frustrated. So are they not hearing us upstairs in Congress? What's going on? What is your organization doing to try to help promote basically more awareness, to maybe change public minds? Where do you see this going? Do you think, is there a way we can change the minds of the legislator to have them, enact legislation that will help employers?
We can start with Dianne Feinstein and Boxer. But so yeah, that's why we did the report. And we've done a couple of conferences, one on H-1Bs, but this other one on immigrant entrepreneurs. We also did a myths and facts piece on immigration, which I think you'd find very detailed. I think it's the best I've seen, actually. It's the only thing I've seen from the business community. But that's one reason we did that. And there are a couple bills on the Hill. One by Senator Lugar, who's having trouble in his primary because he's been too pro-immigration, I think is one of the problems. There's the bill on the end, one of his entrepreneurial visa bill, which says if you're committed, you come to the country and you create something that employs, I can't remember, don't hold me to it, 25 jobs, and it has a certain minimal amount of capital investment. It's like the EB-5 investor visa, but it's not the same. And if that works for 2 years, then you would get something equivalent to a green card. So there are some bills up there. Are those the kinds of things that might be packaged with smaller sort of immigration reform, like as part of this E-Verify vehicle? there's a little laundry list we got in our head, and we're checking it twice every Christmas, and that's one. That's one of them, per country, STEM legislation. But you're going to have, I think as Morton mentioned, something that's going to have, you're going to have to attach it onto to a mandatory verify bill. I think. Not STEM so much, but I mean, not the per country bill, but yeah, go ahead.
So what I've seen is that because of the whole lobbying efforts,
Hi, I am not an attorney, but I have just basic knowledge of some basic laws of immigration. What I want to understand is that most of these laws are being lobbied to help big corporation instead of helping real people who can help the system, like educated, talented people. And from one point of view, most of the immigration laws are still being tied up with the employer, which is another form of slavery, like 1600s, where employers are supposed to, take care of everything for you, and you can't change your employers or whatever. But coming back to the concrete point is that a lot of laws, small corporations have criticized that they help big corporations, like IBM, Microsoft, Google, because they have a lot of infrastructure to help and understand and propagate paperwork. So what's your take on that, that laws should help big corporations or small corporations, or if they be neutral, or they will help more for startups? Thank you.
Well, we tend to not favor sort of, the government driving the economy with its decisions and favoring one group over another. We could support the TARP bailout. I think when it comes to supporting small businesses through the SBA, we support that. I think we're not one, though, to want to empower the government to, I think, favor companies by their size, if this is what you're getting at, because we don't want the government mucking around in the economy like that. Now, some people disagree. But there are obviously times when the government is helpful to business, and we support those provisions. But normally, I would say we try and stay out of that area. It's an interesting, in the immigration area, there's been a lot of talk about, of course, premium processing is part of the deal already, but creating for the L's and the H's sort of special categories for larger businesses that are pre-approved. I didn't say larger businesses, but it would be larger businesses. They're pre-approved for quicker processing because they've got a big name and they've gone through a certain stamp of approval by the government as a good company. A lot of those are all my members are good companies. But, I hesitate to go down that road because then you have the government picking, this is a good company and this ain't such a good company. And I think that's a road that's troublesome.
And you people that have been practicing longer than you correcting questions. In our defense about rolling over and taking it, I think that the consequence of not moving forward with a really bad decision by a service center is just that the company may lose the employee sooner than they wanted to. It's not a big fine. It's not going to be a big drawn-out media blitz. It's just, well, we decide, do we keep this guy or do we don't, or do we not? So I think as attorneys, we can be like, yeah, let's go to court. And they're like, well, why don't we'll just let him go when his H-1B runs out, I guess, if we can't get the perm approved or we can't get the I-140 going forward. So it's not necessarily that we want to roll over. It's just that it's a really big deal sometimes, unfortunately, for just that one employee.
Yeah, but you take that, if the policy that resulted in that one employee being disqualified is going to result in the next 30 being disqualified, I mean, cumulatively, and this is our argument under L's, it has an adverse effect, and maybe we'll get to the point where enough companies get together and say, well, we'll fund a lawsuit by the chamber or someone else because of the cumulative effect. I'm just saying, I was on vacation with my son on a motorcycle trip out in Las Vegas, and when the NLRB regulation came out, I had a call like that morning from a guy putting up $100,000 for the legal challenge. I don't get that in the immigration area. And unlikely this guy was going to be organized by the unions either. It was kind of a principled thing, but it might have been. But it was boom, and we were off to the races, and we won the case too. So you're right, I get your point, but there is this cumulative, and certainly we're seeing that in the L's, I think, finally.
I have one last softball question since we're almost out of time. I'll use my own rule. And maybe it isn't such a softball question.
If you had a magic wand, which hypnotized all of Congress and the executive branch, you could wave it and change one specific thing, what do you think that would be? And I'm not asking code for like what's the chamber's #1 priority, but rather what one thing do you think would be transformative enough to actually make a difference if there was such a change that could happen, preferably in the immigration space, not the union or NLRB space?
I'm going to change the immigration law, not in the way Congress understands things.
Right. Not so. Yeah. So assume away Congress. Don't laugh.
Oh, a dictator. Benevolent dictator. Well, if I could, if I get in trouble with this though. The one issue it appears Congress is never going to be able, or is having the most difficulty taking on in the immigration front, and yet to me is the most troublesome as a matter of both humane treatment and where this country's going, is the issue of legalization. So if I had a magic wand, it would be to take care of that. Obviously, it has to be a targeted program with civil fines and clear criminal penalties and for the bad guys.
Congress isn't here, so you can do whatever you want.
So that would probably be it, and then the rest would be, the temporary worker programs are real hang up on with the unions is over temporary worker programs and negotiations. E-Verify and obviously more enforcement at the borders, which, by the way, I don't think Bush or President Obama get the credit they deserve for the security that's increased at the borders. But that's a whole other PR issue, more of getting the word out, I think. So that would probably, and my memory, when we went down this road 10 years ago, I thought I'd get a lot more blowback from my small business members over our position on legalization. Rarely. Now, when something's on the Hill, my voicemail fills out with "you scumbag" and "anti-American" and that sort of thing, but it's not my members. So,
Yeah. With that, I think we're going to say thank you very much.